What's up, guys? I'm just downloading some stuff right now. I wasn't really planning on doing the stream, but I said screw it. I got a few more beers, a few more smokes, so let's see what we got going on. Yeah, we got sound, brother. As long as you guys can hear me right now. If you can hear me, we're good to go. If you can't hear me, well, I'm running my smoker for nothing. I'm always in deep thought. Deep shit, but deep thought. What's the over and under on how long it took DLD to fall asleep? Like what, 2 seconds after he ended the stream? He was pretty much asleep on the stream, which hell, I might do by the time this is over. Right now, we are partaking of the Keystones, which is my typical cheap ass beer. Everybody made fun of me last night for drinking White Claws. So. Let me see. Let me switch back over to this other tab so I can see where this is at. Oh, fuck me. Did I hit that wrong? I think I did. Damn it. Damn it. Damn it. Coop's a moron. Get the fuck out of the way. Okay. All right. It didn't set me back that far. It shouldn't take long for this to download. So the plan for this stream is to just kind of bounce around on this a couple days of testimony from this new Supreme Court justice, because let's face it, there's no way Republicans are going to block her, and just to, I don't know, make fun of some of this shit and actually see which senators actually made sense when they questioned or tried to question her. Yeah, dude, White Claw, seltzers. I'm a fat boy. I don't want to quit drinking, and they're less calories than anything else. Fire me. If you fire me, you have to hire me back tomorrow for at least half of what you paid me yesterday. So, I mean, we're in good shape. Let me shut this door real quick. See, I told you it'd be quick. Oh, man. Well, this judge, the thing is, she's not going to really change the composition of the Supreme Court right now. The thing that's going to hurt us is she's going to be on the Supreme Court for a very, very long time. And if Biden and Democrats do what they want to do and they pack the Supreme Court, adding more justices, well, then that gets a lot more into actually hurting us. Priest, what's happening, brother? Let me see. Let me switch back over this other tab and see whether this says downloaded. So let's download that. And I think we might be ready to rock and roll with some actual content besides just my fat ass running my dick smoker. Let's see what it does. Let's see, downloads. Open the downloads, computer. You're fucking with my groove. Which one is this one? All right. So let's see. I think this should come up and running. All right. I'm a complete chimpanzee, but I'm learning.
There are today's hearing the easiest.
The only thing that sucks is I can't stand.
I wanted to put some context here.
All right, can you guys hear that and still hear me over it?
Said of your position on this issue. Judge Jackson has a pattern of letting child porn offenders off the hook for their appalling crimes.
Yeah,
Both
she
as a
does.
judge and a policymaker.
Let's see. I'm going to try to get to a couple of different people dealing with her. If I can do this without.
Whistleblowers who shine
Because
a light
there were a
on
couple
fraud
questions on
use of
the Second
government.
Amendment
So I'd like
that
to
she
ask you a couple
completely
questions.
passed up on.
And I'm going to start with,
And there were some other
former
things that
Attorney
were just
General,
absolutely
unnamed,
fucking
once
hysterical.
suggested that key Tam's suits were, in his words, patently unconstitutional, and another word he used was dangerous. He argued that it violated the Appointments Clause. So, understanding that you may get a case before you on the False Claims Act, but maybe this appointment clause is
We ain't worried about the False Claims Act. There's much more interesting shit besides Chuck Grassley's old wrinkled ass I want to look at.
held that can be interpreted by looking to international law.
Yeah, we ain't looking at international law either. They can get bent. Hold on. What was old Charles Lady talking about? I can't remember whether I caught this in
another statute
real time
that
or not.
Congress has enacted to direct agencies with respect to the manner in which they exercise their discretion. So I said, and I believed, that sole meant that the Department of Homeland Security was the only agency who got to make this determination as to how many months a person should be in the United States. And unreviewable meant it was final. Once the agency decided, then there was no ability to review substantively their determination. And I should say,
Now, what she just said right there, how does that fit in with the ATF? Once they make that ruling, it's pretty well final, no review. If she'll hold that for Homeland Security, you honestly think she's not going to hold it for the ATF? Giving that discretion to them? Are we getting a feel for her yet?
that importantly, the statute that Congress enacted gave the agency the discretion to make this determination between 0 and 24 months. There is a limit in the statute. It says Department of Homeland Security, you get to decide.
Now, let me see. There's a couple other people.
Federal public defender, myself as a prosecutor.
Oh, yeah, you just
And
want to
the
either
federal
snatch the whole
defender
damn
here in
time. Fuck
Washington,
off, dude.
You were assigned to, and then
There were some good questions by a couple of people, and I got to remember where they're at. Hold on. We'll listen to old Lindsey Graham, since he actually developed a set of nuts when John McCain died, which leads me to some real questions about this cat.
Some organization called the OWL that didn't admit women. So I guess the reason I'm bringing all this up is it gives me a chance to remind this committee in America there are two standards going on here. If you're an African-American conservative woman, you're fair game to have your life turned upside down, to be filled.
Now, what Lindsey Graham got into here is there have been multiple minority conservative judges that have been nominated to courts, and the Democrats absolutely blocked them, filibustered them, and shut them down. And now they want to cry racism when someone just questions this appointee to the Supreme Court.
Filibustered no matter how qualified you are. And if you express your faith as a conservative, all of a sudden you're an effing nut. And we're tired of it. And it's not going to happen to you. But it just appalls me that we can have such a system in America, that if a conservative woman wants to stand out and say, I love my family just as much as you love yours.
And right there, he was getting into Amy Coney Barrett, who the left called an absolute lunatic because she happened to be conservative and Christian, and a woman. Yeah, brother. It's like I said on the End of Darks chat, I will probably start this up because I'm still awake and I still have some beer. So, yeah, we're just going over some general BS with this new Supreme Court, going to be Supreme Court justice. I will say that because the Republicans are ballless and are not going to block her. You have to remember, as much crap as Lindsey Graham talks right here. Okay, Lindsey Graham has voted for every Supreme Court justice that the left has nominated. Sotomayor, Elena Kagan, he voted for them to go onto the courts. And he's actually talked about that, meaning he's fucking worthless.
And my faith means just as much to me as it does you, that all of a sudden there comes some kind of weirdo. A guy like Justice Alito, who's in the same type situation you're in, being in a group, doesn't agree with everything they do or what people may say at a meeting he didn't go to, all of a sudden they own it.
Oh,
This stuff needs to stop.
fucking get over it.
Our people deserve better respect, and I hope when
That's
this is
just
over,
something about the left. You have to understand.
at least
These
we'll agree
people
to be on
fight
agreement.
so damn dirty.
So now let's talk about Gitmo.
And these nutless wonders that we have supposed to be on the
Would you
right
consider that
will
rewarding?
not stand up to it.
Senator, yes, I did.
Hold on. Let's find something because I remember this line of questioning.
At Morrison and Forster, which was my law firm, in the Supreme Court and Appellate Group, one of the partners at Morrison and Forster was a former federal judge who wanted to make this argument and who said, I have former federal judges who are friends of mine who would like to join with me to make this argument. So I worked with her, the partner at my firm who was a former federal judge, to make.
So it was her idea to get former judges to write this,
Yes.
not yours.
Yes.
And you just helped in the implementation of that idea.
So, Senator, as a member of the Supreme Court and Appellate Group in a law firm, that is
Yeah, they are definitely
Right. No,
definitely
no,
manipulating all of
Yes.
It
us.
wasn't your idea, it was somebody else.
Yes.
Okay.
So they're talking about an amicus brief that she signed on to.
So now, there are people still held at Gitmo today. Do you understand that?
Yes.
Okay. What system is in place regarding their future?
I am not aware of the system right now. I'm not sure exactly
Well,
what you
let
mean.
me tell you what it is.
Yes.
There's a periodic review process made up of an interagency where they go through the files of these folks and they determine whether or not they still present a threat to the United States or the world at large. And I think it's 6 months, maybe a year, but that goes
Yeah.
on at least on an annual basis. And if there's
If I knew our government was honest,
still represents a threat,
I
to
would
the
have
United
no
States,
problems
they're
with
continuing to
Guantanamo
be
Bay.
fined. That's the way the system works.
However,
Are
in
you okay with that?
my lifetime, they have proven to be liars.
As a policy matter, Senator, I'm
So I'm
not
really
speaking
on the
to
fence
my
when it
views.
comes to
That's my understanding is that
indefinite
the periodic
detention.
review
Yeah.
system is an executive
Unless you're a child
branch
molester, then you get fucked.
determination of whether or not they're going to continue to hold people that they
Literally.
Makes sense to you as a way to deal with these detainees?
Senator, I'm not in a position to speak to the policy or the discretion of the executive branch regarding how they're going to handle detainees.
The reason I mention it is because in one of the briefs, you argued that the executive branch doesn't have that option. That if you had had your way, the executive branch could not do periodic reviews about the danger the
Do something.
detainee presents to the United States. They would have to make a decision of trying them or releasing them. Is that not accurate?
They
Respectfully,
should be
Senator,
tried
that's not
or
my
released.
argument.
One of the two.
I was filing an amicus brief on behalf of clients, including the Rutherford
There's a link
Institute,
if anybody wanted to
the
bounce.
Cato Institute, and the Constitution Project, who
When you sign on to a brief, does it not become your argument?
it does not, Senator. If
Oh,
you
wow.
are
Okay, if I sign on to a legal brief or an amicus brief, then that means that I agree with said brief. I am signing on, I'm co signing to that argument. And she is trying to back out of that. Now, I will say this with anybody held in Guantanamo Bay, they should be tried in a reasonable amount of time, and they should either be convicted of something or be released. One of the two. Um, the federal government, being as trustworthy as they are, shouldn't merely be able to accuse someone of a crime, black bag them, and throw them in a jail cell. Um, if we let them do that anywhere, they will do that here. And I'm not cool with that. Um, if you were picked up on a battlefield as an enemy combatant, you should be treated as an enemy combatant. You should be tried under the UCMJ, and your ass should serve whatever term that they come up with from that. If there's not enough evidence to convict you on that, you should be released, just like any other free human being on this planet.
You are an attorney and you are representing a client. Those statements that you
We got to listen to some Dianne Feinstein. Let's see if we can get to this.
And then we'll move on.
Hold on. Apparently, I skipped part of her.
So
Lindsay, shut up.
Whether he believes that Roe was settled wrong, and if so, whether it was correctly settled. Justice Kavanaugh said,
And just remember, this is the wrinkled old bag that actually said on TV that if she knew she could get enough votes to strip all Americans of their firearms, that she would do it. And if she is in favor of this judge, that should tell you something about where this judge is leaning. Much like my pecker, let me just give you a clue, it's to the left.
that Roe, quote, is settled as a precedent of the Supreme Court, end quote. He said that Roe, quote, has been reaffirmed many times over the past 45 years, and most prominently, most importantly, reaffirmed in Planned Parenthood v. Casey, end quote. And he described Casey as having the value of a precedent on precedent, end quote.
I think she's talking about
Most
Justice
recently
Breyer
spoke
right
about
here.
this issue with Justice Barrett in 2020. I asked her whether she agreed with Justice Scalia's view that Roe was wrongly decided. She committed to, quote, obey all the rules of stare decisis, end quote, if faced with the question of whether to overrule Casey. She said she had, quote, no agenda to try to overrule Casey, end quote. So here's the question. Do you agree with Justice Kavanaugh that Roe v. Wade is settled as a precedent? And will you, like Justice Barrett, commit to obey all the rules of stare decisis?
Now, if a judge simply obeyed the rules of things like stare decisis, then any court challenge to things like slavery or segregation never would have been overturned. Just because something had been precedent in the past didn't make it good then, and it doesn't make it good now.
In cases related to the issue of abortion, end quote.
Thank you, Senator. I do agree with both Justice Kavanaugh and Justice Barrett on this issue. Roe and Casey are the settled law of the Supreme Court concerning the right to terminate a woman's pregnancy. They have established a framework that the court has reaffirmed And in order to revisit, as Justice Barrett said, the Supreme Court looks at various factors because stare decisis is a very important
Yep,
principle.
sure it is.
Provides and establishes predictability, stability. It also serves as a restraint in
But
this way. On
all
the
that should
exercise of
matter
judicial
is the
authority,
text of the
because the court
Constitution when it
looks
comes
at
to a law, whether you
or
like it or
not
not.
precedents are relied upon, whether they're workable, in addition to whether or not they're wrong, and other factors as well. So I agree with both of those statements that you read.
This is a chick that would absolutely rule in the government's favor on any gun control
I'm
case.
particularly interested in the case of Roe v. Wade. Roe was decided by nearly 50 years ago, and it's been reaffirmed over a dozen times since then. So my question is this.
So my question is this. If abortion is never mentioned in the Constitution as a right, and the right to life, liberty, and the pursuit of happiness, however, is mentioned, how does abortion fit into this? If you look at our founders, when it comes to things like this, it means I have no right to unduly deprive someone else of life, liberty, or property. And I believe that a baby in a womb is a life, and I have no right to unduly deprive them of life, liberty, or property. Um, all right, Heath, I have to look it up, man. Matter of fact, let me post that up here and everybody can see it a little bit better. But yeah, dude, I'll have to look it up. But yeah, I'm sorry. The placenta that is around the baby serves a purpose into protecting the baby, one, from the mother's immune system. If there was no placenta, the mother's immune system would attack the unborn baby as a foreign body because it is separate in most ways from the mother. It is a separate life. That is basic human biology. So to say that a woman has a right to pay someone else to murder said child in the womb is no different than a woman paying somebody to beat her child to death on the street, as far as I'm concerned. And it doesn't matter how bad your little hellion is, you don't have the right to pay someone else to kill them, whether in the womb or not. That might not make me popular, but I believe what I say.
Does Roe v. Wade have the status of being a case that is a super precedent? And what other Supreme Court cases do you believe have that status?
Well, Senator, all Supreme Court cases are precedential, they're binding, and their principles and their rulings have to be followed. Roe and Casey, as you say, have been reaffirmed by the court and have been relied upon. And reliance is one of the factors that the court considers when it seeks to revisit, or when it's asked to revisit a precedent. And in all cases, the precedents of the Supreme Court would have to be reviewed.
Give me just a sec.
To those factors, because stare decisis is very important.
Thank you. If you are confirmed, you would be one of only 2 justices who has also served on a federal district court, the other being Justice Sotomayor. In your 8 years as a trial judge on the D.C. District Court, you wrote nearly 600 opinions and presided over 9 jury trials and 3 bench trials. As you know from your service on the district court, it's important for appeals courts, and especially the Supreme Court, to be clear in their decisions. The clarity is necessary, as you well know, for trial judges to effectively do their job and properly apply legal precedents that are fair and consistent. As a district judge, you were responsible for applying precedent from the Supreme Court and the courts of appeal to your case. And now as a judge in the D.C. Circuit, you're drafting those precedents. Your experience as a trial judge is one of your most significant assets. And
Now, the only reason you would want to be in front of this particular judge, judging by her record, is if you're a pedophile, and then this is absolutely the judge that you want to draw out of that particular stack of judges. Just saying.
just want to add a personal comment. This is a tough place, and you are handling it very well. And I appreciate your directness and think that's important. Here's a question. I have 2 related questions. How did you make sure that you were properly applying the relevant precedents as a district court judge? And if you're confirmed to the Supreme Court, what would you do
All right,
to
we're going
make
to bounce
sure
this a
your
little bit.
opinions are clear? Here's a question. I have 2 related questions.
The important service that they provide.
We'll have a lunch break. This
Landed or not, that the client
Yeah, and then the talking heads get rolling.
apply precedent. But would you agree with me that even under an appropriate stare decisis analysis, that Dred Scott and Plessy versus Ferguson were appropriately overruled by the Supreme Court?
Well, Senator, I've not.
Now, those were 2 cases having to do with very racist ideals that the Supreme Court upheld for a while, stare decisis, that were then later overturned.
Not engaged in the actual analysis, but I think it is well established now.
Hey, Ban Talk, how's it going, brother?
That overruled Dred Scott and Plessy were correctly decided.
Yeah, I mean, there is a means by which the courts can correct their mistakes, correct? By overruling previous decisions?
If the various considerations that the Supreme Court has uses to make that determination are satisfied.
Have you ever heard a federal judge talk about super duper precedent or super precedent?
I have not.
I've never seen it.
Now, I mean, you will hear Democrats talk about it.
The Judiciary Committee on a number of occasions when somebody has a favorite case or outcome that they don't want to see the Supreme Court revisit. Let me ask a minute. Obviously, your nomination by President Biden is historic. And
I'm sorry. Her nomination by President Biden isn't historic. Democrats have stopped just about every minority person, male or female, that were going to go on the court that had any kind of conservative leaning. The only thing historic about her nomination, well, I can't think of one. Fuck it. We're just going to roll it because she's just an absolute leftist and the Democrats are going to push her through. That's the only thing that really fits in here.
I congratulate you again, congratulated you previously, and I think it's been long
Hey, Ron, take it easy, brother.
overdue. When Clarence Thomas, the second African-American who was nominated to and confirmed by the Supreme Court, was nominated to the court, did you celebrate that as a historic event?
I'm trying to remember where I was at the time. I believe I did. Yes.
When we're talking about staying in your lane, and I appreciate your responses to a number of the questions, even though I'd love to get your.
Now, Clarence Thomas, when he was nominated, the Democrats absolutely tried to destroy that man with every BS allegation they could come up with. For those of you that watched anything about the Kavanaugh hearings, multiply that by 10, and that's what they tried to do to Clarence Thomas. Clarence Thomas actually went to the point of calling it a high-tech lynching, what they were trying to do to him. And it very much was. And guess who was leading that whole shit show? Joe Biden. What's up, Bob?
Answer to the question, but where you've deferred answering, saying you want to stay in your lane and not be seen as a policymaker. Would you agree with me that
what's happening,
the most
PLA?
important questions under our constitutional form of government and the separation of powers is who decides? In other words, some questions are appropriately decided by judges who are elected.
If I can hit the right button one day.
Serve for life, insulated from politics. And other decisions are appropriately within the, left up to the legislative branch.
Yeah.
Because
Yeah. PLA, I know the feeling.
accountable to the people who can vote for us, they can vote against us. If they don't like the policies that we enact in legislation. Would you agree with that? Who decides is an important question in terms of determining the appropriate role for both the judiciary and the legislature?
As a general matter, I agree. It rarely comes directly like that as an issue.
Yeah, PLA, this is the
It's usually
chick who
not a
actually
jump
said
ball
in a
between-
congressional hearing she couldn't define what a
between the
woman was,
legislature and the
I
executive.
get it.
even
You
though
don't
she's
get
a woman.
A lot of easy questions.
Well,
But you, as a general proposition, you won't disagree with me.
what I'd say is that the courts are properly tasked with resolving legal questions, and that
Cases are controversies, right?
exactly in
Right.
every case. And
Congress is not similarly constrained. We can pass broad policies, comprehensive legislation, changing policy, but the difference is, one of the differences is the voters can unelect us if they don't like what we're doing.
that is true.
I want to
Damned of it is she's more than likely, it's 99% she's going to go on the court. So any challenges to what the ATF is doing right now, she's going to be a deciding vote in that decision. Now, again, she doesn't change the makeup of the Supreme Court at this time, as long as something crazy doesn't happen. It's still going to be a 5-4, basically a 4-4 court with a swing vote from a supposedly conservative justice. So you take that how you want, but she will be a deciding vote. More than likely, any challenges to what the ATF is doing, she will be signing on to any dissents that will be published, which is going to be kind of interesting reading what she has to say about said subjects.
ask you, did you study under Lawrence Tribe when you were at Harvard?
I did not.
Well, as you know, Justice Breyer, your mentor, wrote a little book called Active Liberty. And Lawrence Tribe, who was formerly a law professor at Harvard, wrote a review of that book in the New York Times Review of Books. And the title of it is Politicians in Robes. Are you familiar with that article?
I am not.
Well,
oh, you should be. Let's not forget, any piece of bad law that has been passed by our Congress, any bad decision that has been made by an alphabet agency, for the most part, and for many, many, many decades now, has been upheld by these 8 to 9 people, 7 to 9 people in black robes. And those laws that are upheld by these idiots are the laws that put us in prison. That's the reason they upheld the 34 NFA. That's the reason they upheld the 68 Gun Control Act. Yeah, all these things stack on. They are challenged. The bump stock ban, which is still going back to the Supreme Court. Hopefully that will be taken up again and decided properly. Those, we'll just say 9 people decide a lot of things that affect all of us as firearms owners.
In the article, Professor Tribe accuses Justice Breyer of engaging in what he calls a noble lie. And he said, he talks about the morality of resorting to falsehoods and delusions to conceal, usually from the masses, but sometimes from oneself, the truths whose revelation would wreak havoc or at least do more harm than good. Professor Tribe goes on in criticizing Justice Breyer's book. He says in his stubborn
What up, G23?
avowal that the court, even with its current far-right supermajority, remains an apolitical body, he perpetuates a lie that is anything but noble. You've talked about staying in your lane, not making policy decisions, not being seen as political.
Yeah,
Do you agree
bro,
with
that
Justice
makes me
Breyer
happy.
or with Professor Tribe?
Senator, I believe that judges are not policymakers, that we have a constitutional duty to decide only cases and controversies that are presented before us, and within that framework,
I appreciate it, brother.
judges exercise their authority to interpret the law and not make the law.
So you would agree with me that judges should not be politicians?
Yes.
And she's lying through her damn teeth because she knows good and damn well that she is going to read into the words in the Constitution whatever she wants to read into them, just like Justice Breyer does, she is replacing. She clerked for him. She worked under him. She has a more leftist ideology than him. And that is one of the only reasons she is sitting where she is right now. And again, I will go back to, she's not going to change the real composition of the Supreme Court. But Biden is nominating hundreds of judges to lower courts that are just as bad as her. He is, in fact, reshaping our entire court system at this moment, and people don't see it. Take it easy, G. I appreciate you stopping by, brother.
Let me talk to you a little bit about some of the decisions that have been made by the Supreme Court over many years, starting perhaps with Dred Scott, that adopts the substantive due process argument to determine the constitutionality of various laws. Perhaps the most recent decision by the Supreme Court that was a dramatic departure from previous laws in the states and in the nation.
Get to the point.
Was the Obergefell case, which dealt with same-sex marriage. In the opinions that were written there, it was noted that here we are 200 at the time.
Well, I can agree with judges on a court being put in for a lifetime and not being political appointees. I can agree with that. I see it kind of like our founders did. However, their only qualifications for going on these courts should be, will you defend the Constitution and will you measure every law against the Constitution so that if it doesn't fit inside the Constitution, that law should be struck down. It is repugnant to the Constitution. And I do believe there should be a trigger where if a judge makes a decision that is unconstitutional, they should be impeached and replaced. The reason our founders saw them going on the court for a lifetime appointment without being elected was so that they weren't supposed to be swayed by the political powers and the political winds of any given day or time. However, these days, you have judges that are completely political, who make completely unconstitutional rulings. And they should be removed from the court, 100% impeached, and fucking replaced.
234 years after the Constitution had been ratified, 135 years since the 14th Amendment had been ratified, that the Supreme Court articulated a new fundamental right, which is a right to same-sex marriage. You're familiar with that case, aren't you?
I am.
At the time, it was noted that 11 states, including the District of Columbia, had passed laws sanctioning same-sex marriage. But also at the same time, there were 35 states who put it on the ballot, and 32 of those states decided to maintain the traditional definition of marriage between a man and a woman. Do you agree with me that marriage is not simply a governmental institution, it's also a religious institution?
Well, Senator, marriages are often performed in religious institutions.
Well, when the
Is it just me, or was that an absolutely weak ass answer? For gay marriage, against gay marriage, I really don't give a shit. Gay marriage doesn't make my marriage to my wife mean anything less to me. But that was a really weak ass answer. Well, you know, why is government even involved in marriage in the first place? Would be one of my questions.
when you agree with me that many of the major religions that I can think of, and they're Christianity, Judaism, Islam, embrace a traditional definition of marriage, correct?
I am aware that there are various religious faiths that define marriage in a traditional way.
Do you see that when the Supreme Court?
Yeah, you're right, Jeff. They make money off of it, no
a
doubt.
dramatic pronouncement about the invalidity of state marriage laws, that it will inevitably set in conflict between those who ascribe to the Supreme Court's edict and those who have a firmly held religious belief that marriage is between a man and a woman?
Well, Senator, these issues are being litigated, as you know, throughout the courts as people raise issues. And so I'm limited in what I can say about them. I'm aware that there are cases.
No, I'm not asking you to decide a case or predict how you would decide in the future. I'm just asking, isn't it apparent that when the Supreme Court decides that something that is not even in the Constitution is a fundamental right and no state can pass any law?
Now understand, this chick won't answer some of these questions because she is an absolute statist. She believes in the state over the individual. Um, this is the kind of person who would lock up someone in a setting where there are a bakery and they refuse to make a cake for somebody. That's who people like this are. Yeah, and yeah, a marriage itself should be a religious contract. That's what it's always been. Even if you're not religious, if you claim to be an atheist, okay, I don't care. Um, there's something you have to understand about me from the jump. I am all for personal freedom and personal liberty. As long as what I'm doing does not wrongfully deprive someone else of life, liberty, or property, then the government shouldn't even be involved in that. If I want to sign a contract with somebody, which is what a marriage is, and I say that we have property together and that when I die, my property goes to them. If they die, their property goes to me. The government shouldn't even really be involved in that shit. Well, I mean, Jeff, marriage in effect is a contract. Um, it's just not something that the government should have any say so in. It's an agreement between two individuals. Those individuals should be at a certain age where they can legally agree to things, and that's all it should be. Um, and to me, the government shouldn't have a say so in that. They're, I mean, legally, I can't marry my dog. Legally, a 35-year-old guy can't marry an 8-year-old. I mean, there are limits to it, but it's a contract in between two consenting adults, and that covers things like insurance, property when someone dies, things like that. And ultimately, I really don't care if it is between two consenting adults. Um, I'm freedom minded like that.
That conflicts with the Supreme Court's edict, particularly in an area where people have sincerely held religious beliefs. Doesn't that necessarily create a conflict between what people may believe is a matter of their religious doctrine or faith and what the federal government says is the law of the land?
Yeah, and let me touch on this, Bob. Yeah, you're right. This country was founded by very Christianity-minded people. However, if it comes to, say, gay marriage or something like that, does it make my marriage mean any less if two guys can get married or if two girls can get married? No, it doesn't. It doesn't hurt my feelings one bit. Um, do I want to see your ass in fucking bondage gear running down the middle of the road in a parade? No, that is what we call obscene. And no one should be exposed to that. Keep your shit in your own bedroom. Then we have no arguments. Don't try to groom children into your way of thinking, and we have no issue. The biggest thing that we're looking at here is we're looking at a justice who believes that the government should have full control over your individual rights. And that is the point that drives me absolutely apeshit. Because I always fall back to the point that as long as what I am doing is not wrongfully depriving someone else of life, liberty, or property, then the government should get fucked. There's nothing there for the government to get involved in. She, on the other hand, believes that the government should be involved in every decision.
schools in Florida.
Apply precedent. Can choose what they will.
All right, so I hit the wrong button. Fire me.
Was
Senator to White House. This dude's a complete moron. Yada, 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 yada. There were a couple guys I wanted to touch on if I can find them. I should have looked them up in single clips, but there was a few other things I wanted to hit on. Oh, hold on. Come back, Ike Lee.
What the law should be is left
All
to
right.
other branches of government, not to the judiciary. In this respect, we recognize that blind justice and blind justices, those who are blind to the things they're supposed to be blind to, are those willing to recognize that if there is a policy flaw in the law, and if there's a policy change that needs to be made, it's not the role of the court to change it. That belongs to two different branches of government, primarily to Congress. This, of course, requires judicial restraint. It requires judicial humility. And it gets back to what I was describing yesterday when I referred to Justice Barrett drawing on the analogy from the Odyssey of Odysseus binding himself to the mast of the ship. Most of
Crow, you are very, very much right. Our founders talked about a creator or the God of nature, nature's God. And I really think they framed that in a way to include even people that didn't believe in God or didn't believe in a God, or they might have even believed in a different God. It wasn't an absolute religious venture, although it did have certain religious foundings. And the term religious gets a bad rap because, let's face it, people that claim that they are religious tend to do some stupid shit. But it was, the one nation under God wasn't added until much later, Bob. What, in the 1940s or so? But it was about a higher power that was actually forming this country. It sure the hell wasn't about 9 people in black robes that get to make the ultimate decision on our individual rights. And that's where we are at now.
us refer to this judicial philosophy as textualism. Textualism is neither liberal nor conservative. It's neither Republican nor Democratic. It's just the approach that says what the law says matters, and the job of the jurist is to look at the text and figure out what the text means, to ascertain the original public meaning of the text in question. While I doubt there are any members of this committee who would disagree with the idea that justice should be blind in this respect and that policy changes need to be made by the political...
Yeah, and Jeff, you're right. Children are easily persuaded. That's why we look at things that are done right now by the militant wings of, say, the LBGTQAPG fuck me running. They come up with more alphabet every day community. There are certain, it all comes back to the same thing. Thomas Sowell and others, it all comes down to my right stop at your nose, your right stop at my nose. And you don't have the right to apply force to me to get me to do what you think I should do. And it's very much become with in a lot of cases that the very far left gets to apply force to other people to get them to do what they want to do. And I'm sorry, kids, that just ain't right. Everything should be a mutual, agreed to contract.
Branches of government, primarily by the legislative branch and not by the courts. You did hear some statements that I think are at least a little bit at odds with that concept of justice. One of my colleagues mentioned that you should interpret the Constitution in a way that works for the people of today. Fair enough. I certainly don't want to interpret the Constitution in a way that doesn't work. But again, that's not.
No, you don't interpret the Constitution in a way it works for the people of today. You interpret the Constitution as it was written at the time. And people of today need to work their needs around that. And I've had this argument before with people. Okay, the Constitution wasn't written based on the time it was written in. Understand that. The Constitution was written based on human nature, and human nature is never going to change. Not today, not tomorrow, not the day after. Human nature has been human nature since the dawn of time. So our Constitution, our founders, when they wrote the Constitution, they based it on human nature. That's the reason that they wrote the Constitution the way that they did. These people were way more intelligent than your high educated person of today. I hate the fact I say sometimes. You know that? But they were very smart in the way they did this. We're the only free government that has lasted this long in the history of mankind. It's really taken this long for the left, the statists, to destroy this form of government. And make no mistake, they are on a roll when it comes to destroying this free, equitable government that we have.
The objective is not to ascertain good policy. The objective is to ascertain what the law requires. You were urged to consider the effects of the court's actions on people's lives. There again, insofar as this relates to policy, it's not really the job of the courts. You were admonished that you must, quote, be able to see the real people at the other end of the court's rulings, like Americans who are one Supreme Court decision away from losing their health insurance, or one court decision away from
the Affordable Care Act
to make their own health care choices.
If you like your doctor, you can keep your doctor.
Now, that type of judicial philosophy would have you step into the role of policymaker and decide what the law should be rather than what the law is. You also heard quoted a couple of times yesterday, quoted or paraphrased or otherwise referenced Federalist 78, in which Alexander Hamilton refers to the difference between between will and judgment. Will, as expressed by Hamilton, refers to what the law should be. Judgment pertains to what the law is. The judicial branch has the latter power, but not the former. The legislative branch has the former, but not the latter. Judge Jackson, I'd love to get your thoughts on this discussion about what it means, what blind justice is, why that's important. Let's start with this formulation of it, though. Does
Mike Lee, I can't remember whether he gets to it here or whether he gets to it in day 3. He actually nails her down about a couple of things.
Thank you, Senator. The law determines the outcome of a case.
And so anytime you're looking at a case and you're looking at the outcomes for ordinary Americans, for day-to-day Americans, if you're looking beyond the scope of deciding that case, and if you're looking, even within that case, beyond what the law says, you would be stepping into a province of a different branch. Is that right?
I believe so. The law and the facts of the case.
Okay. So, in my humble opinion, and yeah, I'm decently humble about some stuff. I'm fat, I'm short, but I'm decently humble. Much like working from a code book that we have to do in trades, the only thing that matters is the words written on the paper. And if the words don't cover the particular circumstance you are dealing with, then you can't do anything with it. It is black words on white paper. There's nothing in between. The fact that terrifies me is our illustrious government thinks there are gray areas in law, and the alphabet agencies get to decide what to do in those gray areas. That should chill anybody to the bone at this point.
Determine the outcome of cases.
I think that's an accurate statement. It's important to emphasize this. This is also something that Hamilton describes in Federalist 78, where he goes on to say, anytime you start to see the courts start to exercise will instead of judgment, the result is supplanting the will of the people as expressed through their elected representatives through the courts. And that tends to undermine the whole system. You see, there's a reason, of course, why we give life tenure to Article 3 judges and justices. And that is because we want to make sure that they have the power, the authority, the discretion, and the confidence to issue a decision that they might not be comfortable with. In fact,
just to restate what Bacon said at this point, where I am at, it is 3:04 in the morning, and if you are awake right now and you don't have a good buzz on, how do I put this politely? I'm going to meditate for a sec. What are you doing with your life? Because you should be an adult at this point. Just saying, if you're up this early, at least have a buzz. Come on. What are you doing? You suck as an individual.
a judge who always agrees with and is always comfortable with his or her own opinions is, as Justice Scalia used to say, not a very good judge. So we wanted them, you, all, to have confidence in being able to make the right decision, even knowing that you and the public at large might be uncomfortable with the result it produces. Congress makes laws that you won't always agree with. Congress is accountable to the people at regular intervals. You can fire every member of the House of Representatives every 2 years. You can fire 1/3 of us in the Senate every 2 years. We insulate judges and Supreme Court justices from that same accountability precisely for this reason. It's because political accountability is so important. This is borne out in the judicial oath, one of the oaths that you'll take if confirmed to this position as an associate justice, in which you'll swear or affirm that you'll administer justice without respect to persons, and that you'll do it faithfully and impartially. I read this to mean that you do it without consideration of external circumstances, external considerations, policy considerations.
I'll be right back.
Now, this relates to some interaction that you and I had when you came before this committee for your confirmation to the U.S. Court of Appeals for the D.C. Circuit, where you now sit. In connection with that hearing, I submitted some questions to the record in which I asked you whether, to what extent, the Constitution protects rights that are not enumerated in the Constitution itself, and if so, to specify what those rights were. You responded by citing a number of cases, including Griswold versus Connecticut, Roe versus Wade, Loving versus Virginia, and a handful of others. You also suggested that the Ninth Amendment was something, was a source for such rights, unenumerated rights. The Ninth Amendment, of course, states, quote, that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Judge Jackson, what specific rights has the Supreme Court identified as flowing from the Ninth Amendment? And by that, I mean specifically from the Ninth Amendment, rather than in sort of an also-ran list of other features of the Constitution that might back up a particular ruling. What rights has the Constitution identified as flowing specifically from the Ninth Amendment?
Thank you, Senator.
Yeah, Jeff, that's about
as I
right.
understand it, has not identified any particular rights flowing directly from the Ninth Amendment, although, as you said, the text of the amendment suggests that there are some rights that are not enumerated.
Right, right. Its very existence and its very language suggests that, which opens up other questions as to how those are to be resolved. It's led to considerable debate among scholars and jurists alike as to whether, to what extent.
All right, let's speed some stuff up.
Judge Jackson, what specific rights has the Supreme Court identified as flowing from the Ninth Amendment? And by that, start to see the courts start to exercise will instead of judgment. The result is supplanting the will of the people as expressed through their elected representatives. Refers to the difference between between will and judgment. Will, as expressed by Hamilton, refers to what the law should be. Judgment, start to see the courts.
Because
Yeah, we're skipping around a little bit,
the
kids.
way in which the Supreme Court generally prohibit classifications on the basis of race, and it
All of them, I believe, would fall into the category of channels and instrumentalities of spread availability of certain.
You know what? Hold on. She just kisses a whole lot of ass, talks about abortion. Is this one where Ted Cruz really gets into a boxing match on?
as
Now, it's from what I know.
Many Democrats
Shit.
defended him against criticism.
Don't do that.
Or as a framework for your
I got fat fingers. It's a cheese wheel, really. Come on, back up. Keep backing that ass up. Oh, fuck, that's a face to see when you say that term. Excuse me while I go throw up.
Very proud of the fact, but Justice Black.
Now, what I was about to say is, I think Ted Cruz and this chick actually went to freaking law school together. So he has a history with her. He actually knows her.
Supreme Court should maintain its precedents for predictability and stability in the law. If the court...
Yeah, and Ted Cruz hammers her pretty good on a few things. I've got before we get out of here tonight, before I run out of beer and smokes, we've got to get to Mike Lee hammering her on the Interstate Commerce Clause, which I believe the Interstate Commerce Clause is the worst, absolute worst piece of legislation that's ever been passed. And we got to look at Cory Crazy Eyes Booker in support of her because, goddamn, it's just fucking funny. So that's where we're going to try to go. Oh yeah, Jeff, it's a complete fucking mess.
Asked to revisit a precedent, its criteria, what it looks at, are whether the precedent is wrong and in fact egregiously wrong, the court has said, whether there's been reliance on that precedent, whether there are other cases that are similar to the precedent or that relied on the precedent that have now shifted so that the precedent is no longer on firm footing. whether or not the precedent is workable. Sometimes the Supreme Court will issue a ruling and determine later that it's not actually doing what the court intended, and whether or not there are new facts or a new understanding of the facts. Those various criteria are what the court looks at to decide whether or not to overturn a precedent, and they would be what I would look at if I were confirmed to the Supreme Court.
Thank you. I was recalling as you spoke about stare decisis.
Is it just me, or does Mrs. Klobuchar, who ran for president, look like she could take a bite out of a 2x4 or beat a beaver chewing through a tree? Inquiring minds want to know. Come on, get to Ted Cruz. Even though Ted Cruz looks like the adult version of fucking Eddie Munster. Yeah, pretty much.
That America was born in, that the provocative thesis that the America that was born in 1776 was not the perfect union that it purported to be. And indeed, Ms. Hannah Jones, in her 1619 projects, describes the central thesis of the 1619 project, which the New York Times laid out as a revisionist look of history, revising American history. And Ms. Hannah Jones described her central thesis as, quote, one of the primary reasons the colonists decided to declare independence was because they wanted to protect the institution of slavery. Now, that claim is a highly contested historical claim. Do you agree with Ms. Hannah Jones that one of the primary reasons the colonists decided to declare independence is because they wanted to protect the institution of slavery?
Thank you, Senator. When I gave that speech at the University of Michigan, I was asked to speak on Martin Luther King Day. And every year they have a Martin Luther King Day speaker. And I gave a speech about Black women in the civil rights movement. Most of the speech, if not all of the speech, was focused on African American women.
Yeah, Bob, send me the pics, man. You got my email.
Contributions to the civil rights movement, unsung contributions in many cases, and then some of the more recent African American women who have
Jeff,
claims, who have.
Let me mute the hat. God
soft
damn
on crime.
fat fingers. I keep hitting the wrong button. Jeff, I'm in Alabama, over towards the Phoenix City area. Phoenix City, Columbus, Georgia. Yeah, I'm right around that area.
You gave a speech in April of 2015.
Ha! Hit it, not too far away.
Chicago, in which you described the job you do as a judge. And you said sentencing is just plain interesting because it melds together myriad types of law, criminal law, and of course constitutional law, critical race theory. So you described in a speech to a law school what you were doing as critical race theory. And so I guess I would ask, what did you mean by that when you gave that speech?
With respect, Senator, the quote that you are mentioning there was about sentencing policy. It was not about sentencing. I was talking about.
So make no mistake, this chick thinks that race should be added into any sentencing decision that she makes. Doesn't matter what you do. Shake it up in a bag, pull out race, and that should be what the decision is based on. Sorry, if you murder someone as a Black person or you murder someone as a white person, it is still murder. You still took someone's life without just cause, and the sentence should be fitting for both. That's why when you see the whole Lady Justice, she is supposed to be blind. This chick does not believe in that.
The policy determinations of bodies like the Sentencing Commission when they look at a laundry list of various academic subjects as they consider what the policy should be.
Okay, but
Critical
you were
race-
vice chair of the Sentencing Commission, so let me ask again, what did you mean by, because that was an official responsibility of yours, what did you mean by what you were doing was critical race?
What I meant was that there are a number of, that slide does not show the entire laundry list of different academic disciplines that I said relate to sentencing policy, but none of that relates to what I do as a judge.
So let me ask you a different question. Is critical race theory taught in schools? Is it taught kindergarten through 12th?
Senator, I don't know. I don't think so. I believe it's an academic.
She knows. We all know. And this is an absolute gripe, bitch, rant of mine. We absolutely let the left in this country take over the educational system about, I don't know, 50 something years ago. They started before then. They really got traction about 50 something years ago. And this is how we end up with people in college now who can't stand to hear an opinion that is different than theirs, even though college, all through your time in school, you should be exposed to opinions that you don't agree with. Therefore, you develop your arguments against those opinions. She knows exactly what's going on. This is a congressional hearing. This is part of the congressional record. This becomes part of history in the United States, and she is flat out lying her ass off. Take that whichever way you want.
Theory that's at the law school level.
Okay. As you may recall, during the confirmation hearings of Justice Amy Coney Barrett, there was a great deal of attention paid to the fact that Justice Barrett served as a board member on the Board of Trustees of a religious private school, and the press focused very intensely on the views of that school. In your questionnaire to this committee, you disclosed that you are similarly on a board, specifically the Board of Trustees for the Georgetown Day School, and that you've been a board member since 2019 and you're currently...
Yeah, Crow, in a lot of cases, yes, people deserve a lot harsher punishments for what they do. Serial rapists, serial killers, child molesters, people with child porn. Let's put it this way, they should not see the light of day ever. Whether they are breathing or not breathing, well, that's neither here nor there. But they should not be walking around in public.
Still a board member. Is that correct?
That is correct.
In regard to the Georgetown Day School, you've publicly said, quote, "Since becoming a member of the GDS community 7 years ago, Patrick and I have witnessed the transformative power of a rigorous progressive education that is dedicated to fostering critical thinking, interdependence, and social justice." When you refer to social justice and the school's mission on social justice, what did you mean by that?
Thank you, Senator, for allowing me to address this issue.
I can't underestimate how much I hate that whole response starting out. Thank you for letting me yada yada. All she's doing right there, she has been coached to answer or to start her answer with that whole sentence. So then she has time to think about her answer. It's not like having a conversation in between two people, which is how a lot of this should be done. If me and Bob are having a conversation and Bob asks me a question, I don't go, Thank you, Bob, for asking me this question and allowing me to yada yada. I go, no. He asked me a question. I give him a response because it is off the top of my head. It is what I feel. If Crow asks me something, if he asks me something in chat and I answer it on a stream, again, it's 100% off the cuff. I answer the question. How they start their answers in these hearings is absolute, unequivocal horse shit.
Georgetown Day School has a special history that I think is important to understand when you consider my service on that board. The school was founded in 1945 in Washington, D.C., at a time in which, by law, there was racial segregation in this community. Black students were not allowed in the public schools to go to school with white students. Georgetown Day School is a private school that was created when 3 white families, Jewish families, got together with 3 black families and said that despite the fact that the law requires us to separate, despite the fact that the law is set up to make sure that black children are not treated the same as everyone else, we are going to form a private school so that our children can go to school together. The idea of equality, justice, is at the core of the Georgetown Day School mission, and it's a private school such that every parent who joins the community does so willingly with an understanding that they are joining a community that is designed.
Now, just to throw this out there, because I'm going to bounce around here in just a second. This chick will be completely anti-gun. Look behind her and see the gun belt the dude is wearing to protect her, and realize that although she was anti-gun for herself, she is not anti-gun completely. She just wants to subcontract the violence out to other people. And that is something that pisses me off to no end with the left in this country. They're not anti-violence. They're not anti-gun. They just believe in subcontracting that work out to other people. And her answer about the school is complete horseshit. Ted Cruz drinking a Coke, yada, yada.
Right now, the UCLA School of Law Williams Institute estimates more than 6,300 sex offenders are currently detained in civil commitment programs. If the view you advocated prevailed, presumably those 6,300 sex offenders would be released to the public. Is that an outcome that should be concerning?
Senator, in law school, when I was writing a note, I was looking at a brand new set of laws that had not previously been enacted in any jurisdiction. They were new. And I was assessing at the time, as law school students do, what criteria I thought might be used by courts to make a determination in the future as to whether or not they should be treated as punitive and therefore not unconstitutional, but as therefore ones that carry with them certain rights versus preventative.
Judge Jackson, so you've pointed that these were views in law school, and listen, I will recognize that all of us, when we are students, may have views that as time and maturity passes on, we may change. But what troubles me is this was not just a law school view, it's one that has continued. So when you were vice chairman of the Sentencing Commission, you expressed significant concerns that the White House has argued that your quotes were taken out of context. So I want to provide the full context of your quote, because you said, yes, I want to ask you about the means by which we can distinguish more or less serious offenders. I know that all of you...
She's talking in this letter about pedophiles and people who are um, in possession of kiddie porn, and she is arguing for lesser sentences on said people.
Sort of touched on that. Mr. Futrell, you talked about going from singular to one-on-one to group experience. I'm just wondering if there's some sort of inevitable and natural progression from one stage to the other, such that you could say that the least serious offenders are in the singular experience stage. And I guess my thought is, in looking at some of the testimony that other people will have later in the day, I was surprised at some of the testimony with respect to the motivation of offenders, and we're talking about child pornography offenders, and that there are people who get involved with this kind of activity who may not be pedophiles and who may not be necessarily interested really in the child pornography, but have other motivations with respect to the use of technology and being.
Let me ask this question very simply. If you are watching kiddie porn, why else would you be watching it unless you were involved in child pornography? There's one exception that I can think about, and that would be someone who is researching it to basically put these people out into the eyes of the legal system. In other words, someone hunting these bastards down and actually turning them over to law enforcement. Other than that, I really can't see a reason where someone would have hundreds of images of child pornography on their computer and they weren't into diddling children. This chick has literally gone light on sentencing on people who have had hundreds and thousands of child pornography images and videos. She doesn't believe that is an issue.
In the group, and here are lots of reasons perhaps why people might engage in this, and so I'm wondering whether you could say that there could be a less serious child pornography offender who is engaging in the type of conduct in the group experience level because their motivation is the challenge or to use the technology. They're very sophisticated technologically, but they aren't necessarily that interested in the child pornography piece of it. Now I find that a pretty remarkable argument that people in possession of child pornography are not actually interested in the child porn. They're not pedophiles. They're just interested in technology. Is that? And I wanted to provide the whole quote because the White House said that portions of this were used out of context. So this is your entire quote. Do you agree with that sentiment that there is some meaningful population of people who have child pornography but are
well, Bob, it's someone doing research or someone trying to find child pornographers, much like researching anything else, they are going to be exposed to this stuff. As long as you can prove that you are actually turning this stuff over to law enforcement and reporting it, I can see that. However, if I have 10 images of kiddie porn on my computer and you show no record of me turning that over to law enforcement and calling them and saying, hey, this shit is by so-and-so, I got issues with that. It is a serious reason why I couldn't be involved in some of these things because, well, let's just say I would go around the courts and there would be less child molesters in this world. That's just me. They might meet untimely appointments with our Lord and Savior if I was involved in such issues.
not, in fact, pedophiles or getting getting satisfaction from it?
Thank you, Senator, for allowing me to address.
There we go with that same answer. Thank you, Senator, for allowing me to address.
What appears to be a question that I was asking in the context of a hearing on child pornography. You've provided the entire quote, and it looks as though I was asking that of someone, not taking that position. And the position that I've taken in all of my sentencings involving child pornography offenders.
Anthony, let me explain something. She is here because she is black. She has a vagina, and she is a very far leftist that is easy on those who like diddling underage children, which our present president, Uncle Sniffy, very much likes her position on those who diddle children. So, hence, she is here.
Is to ensure that despite the attitude and view of many of the offenders who came before me when I was a trial judge, that they were just lookers, that they weren't really harming anyone, that they were curating their collections and they never touched a child, I made sure that they understood that notwithstanding their collecting behavior, that they were causing significant harm.
So Judge Jackson, all right, you raise your actual sentencing, and I think that's very productive. Let's take a look at your actual sentencing. And you've had 10 different cases involving child pornography. These are the cases. There are two, U.S. versus Buttry and U.S. versus Can, for which the government did not make a recommendation. And you said earlier, when Chairman Durbin was trying to preempt this line of attack, you said it's a sickening and egregious crime, which I very much agree with. And you said the guidelines lead to extreme departures. Okay. Let's look at what the prosecutors are asking for. And I would note that this was in the District of Columbia, where prosecutors are far more liberal than many of the prosecutors in this country. And in every case in which, so United States versus Hess, there was a mandatory statutory minimum of 60 months, and you imposed 60 months because you had no discretion. In United States versus Nickerson, there was a mutual agreement of the parties to 120 months, and that's what you imposed. In every other case, United States versus Chazen, the prosecutor asked for 78 to 97 months. You imposed 28 months. 28 months is a 64% reduction. In United States versus Cooper, the prosecutor asked for 72 months.
Now, hey, you bastards, don't conflate Coop with Cooper on this shit. I'm just saying, nowhere near that.
Imposed 60 months. That was a 17% reduction. In United States versus Downs, the prosecutor asked for 70 months. You imposed 60. That was a 14% reduction. In United States versus Hawkins, the prosecutor asked for 24 months. You imposed 3 months. That was an 88% reduction. In United States versus Savage, the prosecutor asked for 49 months. You imposed 37. That was a 24% reduction. In United States versus Stewart, the prosecutor asked for 97 months. You imposed 57. That was a 41% reduction. Every single case, 100% of them, when prosecutors came before you with child pornography cases, you sentenced the defenders to substantially below, not just the guidelines, which are way high.
Yeah, well,
what
yeah.
The prosecutor asked for on average.
And you wonder why the left wants her.
47.2% less. Now, you said you made sure the voice of the children was heard. Do you believe in a case like United States versus Hawkins, where the prosecutor asked for 24 months and you sentenced the offender to only 3 months? Do you believe the voice of the children right now, the UCLA?
My understanding of the law.
Now I'm going to break off from that a little bit. And we're going to bounce through. But the Hawkins case, it wasn't very long, and that Joker reoffended on some other shit. This guy had hundreds or thousands of images of underage children. And yeah, this chick, instead of 24 months, which should have been a life sentence, she gave him 3 months. 3 months. Yeah, we're gonna do some bouncing because Jesus Christ. Hold on, here's Holly. We'll watch Holly.
To the judicial philosophy of originalism, but you've not adopted it or embraced it as a philosophy or label that applies to you. So maybe one of the places we could tease that out a little bit more is trying to dig into whose jurisprudence you most admire. We've heard many nominees before, like Senator Grassley, former chairman of this committee.
There go my cocks.
So the farming and ranching people.
Where's Corn Pop when my cocks start going off?
John Kennedy is super smart Rhodes lawyer who kind of pretends to be a, aw shucks kind of guy as he picks your pocket. Grassley and
Do I get equal time, Mr. Chairman?
He always gets unequal time. He always gets bonus time. But I think it might be helpful for us to understand who you most identify with, and past nominees before this committee have talked about the mold of particular justices they thought they found.
Okay. Crap, fat fingers. You guys have got to watch the crazy eyes.
Kind of interpretation.
You guys have got to watch the crazy eyes behind Josh Hawley. Yeah.
To assess what it is that the parties who wrote the text intended. And as a result, because my methodology involves these various pieces and because of the way in which I do things, I'm reluctant to establish or to adopt a particular label, because the idea of how you interpret is just one part of the entirety of a judge's responsibility. As I mentioned, I'm looking at the facts in a case. And
there was a better angle of the chick behind Josh Hawley on another feed the other day. She has some of the craziest eyes I've ever seen.
To do that, I think, having heard from parties in all sorts of cases directly as they present their arguments. That's a part of the judging responsibility that isn't really captured by something like originalism or living constitution. And I believe that the Constitution is fixed in its meaning. I believe that it's
no, she doesn't believe the Constitution is fixed in its meaning, not whatsoever.
Appropriate to look at the original intent, original public meaning of the words when one is trying to assess, because again, that's a limitation on my authority to import my own policy views. But there are times when the meaning, unreasonable searches and seizures, due process, looking at those words are not enough to tell you what they actually mean. You look at them in the context of history, you look at the structure of the Constitution, you look at the circumstances that you're dealing with in comparison to what those words meant at the time that they were adopted. And you look at precedents that are related to this topic. All of those tools judges use, and I have used, is if you look at my cases.
But when you say that you look at the intent of the authors of a statute, sometimes courts have to say the people who wrote this statute, whether they meant to or not, have done something that we, the judiciary, decides. Speaking
Now, one point I have to make right here. If you watch the Kavanaugh hearings or the Coney Barrett hearings or any hearings for a judge who was appointed to the Supreme Court by a Republican, there's a drastic difference in between how they were approached by those on the left and those on the right. The people on the right are actually asking her about decisions that she made in her court cases. The people on the left, from Robert Bork on, merely just accused people of shit that couldn't be proved and tried to run their name into the ground.
in the voice of you, is unconstitutional. And deciding that something is unconstitutional requires an interpretive framework for how you get there, right? And so you and I talked in my office about the differences between Justices Kagan, Breyer, and Sotomayor's judicial philosophies. And you told me that you needed time to study that issue.
Let me inform the crowd. Kagan, Sotomayor, and Breyer are absolute leftist statists who believe in the power of the state over the choices of the individual. And she is going to be further left than they are. Put that in your Chairman Juan pipe, Glock style bong, and smoke it, because this chick will be on the Supreme Court unless something seriously changes.
Further. So assuming that you've had a chance to think about that a bit more, I guess I'd ask you again, what are the differences among the three of their judicial philosophies?
With respect, Senator, I have not actually had time with all of my meetings with senators and the work that I've done to appear before you today. I would say that there are differences, as you see from the various opinions that they have issued. I'm not sure which one I would necessarily follow because it depends on the case. I think their differences indicate that they are looking at different provisions. They are using the various tools that judges use and that I have used in my cases. The idea of striking down a statute as unconstitutional is daunting and should be daunting, I think, for any judge or justice, and would have to be looked at very carefully because of the limited nature of the judicial role and the fact that the policies have been adopted by the branch of government that has that authority under the Constitution.
So I guess I'm surprised after 9 years on the bench that, I mean, you're super smart. Nobody disputes that.
I would dispute that. Very much so. Will I say she is educated? Yes, she is very highly educated. Will I say she is smart? No. There's a difference in between educated and smart.
And having worked for Justice Breyer and knowing of some of the fights, some of the philosophical arguments he and Justice Kagan had, it just seems surprising that you wouldn't be able to at least not speculate, but reflect a little bit on the nature of those disagreements. Because to say it depends on the particular case, that's fine, but they have different philosophical and hermeneutic approaches to the text. So maybe another way to get at it. I think Justice Breyer, again, for whom you clerked, and Justice Scalia used to travel together and have lively debate circuit conversations. Can you tell the American people a little bit about what Breyer-Scalia roadshow looked like? What were they arguing about?
Well, my understanding is they were arguing, or at least presenting, two different viewpoints as to how the Constitution should be interpreted. And I would say, just as an aside before talking about their positions, that while I have been on the bench for 9+ years, the
I'll be
issue
back.
of
Hold on.
constitutional interpretation in that sense doesn't come up very often. It comes up to the Supreme Court for sure, but it doesn't come up very often in the lower courts. What Justice Scalia and Justice Breyer, I believe, were debating was Justice Scalia's notion of originalism, meaning that the words of the Constitution should be interpreted as they were written by the founders in the founding era, and that they should not be considered to essentially to establish principles that modern justices could now apply based on their own view of the needs of society. And that Justice Breyer's position was more toward that latter view, that the idea of the Constitution needing to be interpreted in a way that is consistent with modern sensibilities about the principles that the document reflects. And I would just say that it appears now that the Supreme Court has taken Justice Scalia's view that the prevailing interpretive frame for
Hold on,
interpreting
Bacon. I'll
the
crank it up.
Constitution is now very clearly looking back through history. So we see that even in the Heller case, where the justices, even the justices in dissent, were all analyzing the issues in the Second Amendment through a historical lens, what was meant at the time of the founding. So that is now the way in which constitutional interpretation is done.
Okay, here is one of my arguments. The only thing that really matters in the Second Amendment is they mentioned, they actually wrote in, it was the right of the people to keep and bear arms. It wasn't the right of people connected to the militia. It wasn't the right of people that the state deems are so afforded that right. It was the right of the people to keep and bear arms. I've gone through many things with the founders' letters in support of the Second Amendment, where they actually went through their ideas on what that meant. Going so far as to say that people should be trained in arms at a very young age and people should be armed at all times. The Heller decision, Heller 1, Heller 2, were an absolute punt by the Supreme Court. They should have been very simple decisions. It is the right of the people to own and bear arms, period. But they punted on it, and we're still fighting over it to this day.
Do you identify with that position?
I identify with the position insofar as that's how the text is interpreted of the Constitution. That I am a strong believer, as I said, in precedent, in stare decisis, in predictability, in the rule of law, and the way that the law now interprets the Constitution is through this historical frame.
I'm grateful for your last couple of minutes because I think that it's in the American civic interest for us to understand these different schools. Again, non-lawyer here, but my simple way of summarizing some of what I think I heard you just say is that Scalia argues hard that the Constitution has a fixed meaning and justices aren't really free to depart from it without a constitutional amendment passed by the political branches so that the voters get to hire and fire the people or have a role at the state level in the ratification of a constitutional amendment. And Breyer's position seems to me and I won't get it precise enough in technical legal terms, jurisprudential terms probably to satisfy him, but that the Constitution is speaking to more abstract principles, and therefore there's a lot more play in the joints of what a justice's job is. And I think the way you summarized their debate was pretty fair. And I also think it's fair for us to want to understand what your position is about it, because you're obviously, as I've said, incredibly smart and incredibly likable and winsome, and on the stage for a lot of Americans to look up to. I'm at the rah-rah, hear side of that debate. At the level of what is a Supreme Court justice's job, I think that's why a lot of us are still trying to tease out the philosophical distinction, which I think is more
Jeff,
than just a
you're
methodology.
right.
But want to thank you for that answer. You've also brought up the Fourth Amendment a number of times in our conversation, and I would like to talk a little bit more about the Constitution and whether its meaning changes. And so I'd like to go back to the Fourth Amendment topic you brought up in my office. You said, I think, that and correct me if I'm missummarizing your position, you said that originalism wouldn't have much to say about the Fourth Amendment because the Founding Fathers never conceived of a tool, a piece of telecommunications equipment like this. And so I think during our
Again, I will go back to a point that I made earlier. Our founders wrote the Constitution based on human nature, not on anything else. Human nature covers all of this. No matter what technology does, human nature is going to be the same. Whether it is the progression from a stone axe to an AR-15 or written letter to the internet, human nature is the same. Human nature doesn't change.
Conversation, you said that the original meaning of the Fourth Amendment won't tell you much about what to do with a new technology. My guess is that originalists, and Scalia in particular, would disagree. So what do you do?
And again, I say the chick behind Josh Hawley right there has some of the craziest eyes that I've ever seen. That chick would boil a bunny rabbit in your kitchen in a hurry. I'm just saying.
If the text of the Fourth Amendment doesn't answer a question, where do you go next?
Well, Senator, just to clarify
Please.
what I intended to say, and I may well have misspoken, there is an originalist take, I think, on the question of what happens with a cell phone. As the Supreme Court held in the Riley case, there was a way in which you assess principles of the Constitution, the text of the Constitution, and apply it to modern technology. And you have to, because there's no question that cell phones didn't exist at the time of the founding. So if the original
whether or not a cell phone existed at the time of the founding, it doesn't matter whether I wrote a letter, put it in a guy's hand, and that guy transferred it to someone else, or whether I pick up the phone and I dial a number and we have that communication. One is just faster than the other. That is the only thing that has changed.
originalist principle is we look only at the Constitution as it relates to things that existed at the time of the founding. There would be no answer to what to do about a cell phone. And so what the Supreme Court has said and done is to determine that the principle of the Fourth Amendment with respect to searches is to determine whether there is a reasonable expectation of privacy. They also have looked at property interests with respect to whether or not.
Yeah, Jeff, you're right. Human nature has brought us to where we are at this point. Our Constitution was written as a restraint on human nature because, let's be honest, human nature wants power and control. It just took these idiots 200 years plus to find ways around our Constitution. And in a lot of ways, they found that with the Supreme Court.
there's an invasion of privacy, and then determined from history what that reasonable expectation of privacy related to back at the time of the founding, and analogized to current circumstances related to things like cell phones. It's a method of interpretation that allows you to, instead of the alternative, which would be, don't worry about the history, just look at the words in the Constitution and say, what do I think?
Now, understand, this is the same woman. I will use that term, even though she can't define it, that will say that, well, our founders only talked about muskets. They never thought about anything like an AR-15, even though our founders were trying to get their hands on things like the puckle gun at the time.
Is reasonable or unreasonable with respect to police officers searching cell phones. That's not the way the Supreme Court handles it. They try to determine what was unreasonable historically, and then given those principles, historically it would be unreasonable for police officers to enter someone's home, to rifle through their papers and documents. They then analogize to current circumstances and the fact that a cell phone is like your personal file cabinet. And they say, okay, given what we understood the framers to have intended about the need for a warrant or the need for protection against unreasonable searches, we're going to apply that to modern circumstances. It's still an originalist way of analyzing.
No, Bob, she has just been coached.
So are there non-originalist ways
much
to wrestle through that same question? And what would they be?
One could imagine that rather than referencing history at all, that the court would look at the Constitution. It says no unreasonable searches and seizures, and would just ask in the...
Yeah, Jeff, you could think of a puckle gun as a very early Gatling gun. From research that I've done, it was basically a black powder gun in multiple chambers. So every time you turned the handle on it, it was flint striking each individual chamber. Our founders wanted repeating firearms. Different than something like a volley gun where you have multiple barrels on one platform, but they all fire at once. Something like a duckbill where you have like 3 to like 6 barrels that are spread out in a V. Well, this was a Gatling gun configuration. Circular configuration, multiple barrels, each one topped off with powder, loaded just like a regular black powder gun. And as you turn the crank, the flint would come and strike each individual flash pan and set the round off. They were just really expensive at the time, and let's face it, our broke asses couldn't afford it and fight a war at the same time.
In light of modern sensibilities, in light of what we would think would be reasonable today, or what the court itself would think would be reasonable today, we'd apply that modern understanding to the cell phone situation. And the danger, I think Justice Scalia would say, is that that's a kind of framing that permits judges to make a determination based on their own views rather than hewing themselves, as Senator Lee said before, that Justice Barrett pointed out, hewing themselves to the text of the Constitution.
And does Breyer have a different view?
I haven't, I'm just trying to think. My understanding of the living constitutional principle is that it's closer to looking at the needs of modern society. But I'm not well versed in it, in part because...
Okay, let me throw this in here. The needs of modern society are no different than the needs of any other realm or date in our society. That hasn't changed. That's the reason we can be on YouTube right now and we can see visual representations and we can do this in real time versus someone having to write a letter and send that on with someone on horseback to get it to another person. It makes snail mail look like it's fast. The direct lineage of a firearm goes from an actual handheld cannon to the AR-15, semi-automatic, G3s, you name it. All of that is there. But our rights and the restrictions on the government don't change. It is all human nature. It has nothing to do with technology. Yeah, Crow, yeah, there were volley fire guns. They had multiple barrels. You loaded up all the barrels, 16 barrels, 10, 20, fuck it, didn't matter. And when you pulled the trigger, all of those went off at the same time. The firearms technology was something that our founders knew was going to grow. They had an absolute grasp on that. They understood it. And yet you have liberals to this day saying that the Second Amendment is outdated while they are arguing for the First Amendment on their Apple AirPod, what the fuck ever. I'm sorry, our rights don't change with technology.
As the Supreme Court has now so clearly taken the historical perspective, the originalist perspective in its interpretations.
You brought up the cell phone example with me, but I know you have others. What are some other areas of life where the original meaning seems to be 2.5 centuries removed? What are places that the Constitution seems to not speak to?
Well, Senator, I'm reluctant to spell out different circumstances. What I will say is that when you look at the language in the Constitution, there are some provisions that are completely clear on their face.
Well, here are some absolute arguments when it comes to the Constitution. One is our founders stated quite in your face and 100% out in the open that if it was not a power given to the government, that power was to the individual. There wasn't a gray area at all in it. Period. The only way the government could do more than it was actually designed to do would be through constitutional amendments. However, our government does that through regulation. I will talk about this till my dying day. When the left took over the educational system in the United States, that was basically the slow death of freedom and the United States. Take that as you will.
Without any question of what was intended, the age of the required age of senators, the required age of the minimum age of the president, these kinds of provisions, all you need is the text, and there you are. But there are provisions of the Constitution that are broader than that, and therefore some interpretive frame is necessary. And to the extent I mean, every question the Supreme Court gets that involves new technology, for example, that relates to constitutional provisions will require some kind of analogy, I think. But, you know, I can't speak to anything more than that.
You have described Justice Breyer's constitutional approach as pragmatic. What does that mean?
I understand it to be, and his approach to be about ensuring that the rules that follow from the Supreme Court's determinations are ones that make sense. And
Now, let me stop this here. For those of you who have watched me for a little while, we did a live stream on a Supreme Court argument where a guy told his uncle wanted a certain gun. He told his uncle he could get a better deal on that gun where he was at than his uncle could get where he was at. So his uncle sent him a check for the gun, for the amount of money for the gun. The guy purchased the gun through an FFL, went through a background check, passed said background check, delivered the gun to his uncle, and then went through an FFL to transfer the gun to his uncle. That's 2 FFL background checks, 2 federal firearms, 2 NICS background checks on that firearm, documented. And Justice Beyer, who she is going to replace, who she is talking about right now, wanted to throw that guy in prison for 10 years for a straw purchase. Even though he went through a background check when he purchased the gun, he made his uncle go through a background check when he transferred the gun, meaning neither one of them failed any background check. But just because they say he lied on his 4473, they wanted to put the guy in prison for 10 years, and Beyer was completely okay with that. This chick is going to take his place, and she is further left than him. I'm just saying there's some issues with her.
are workable.
He said recently, explaining his approach to interpreting a statute, you're not going to go outside the words, but it often doesn't give you the answer. And you look at the history and you look at its purposes and you'll look at consequences too, and you'll try to evaluate them from that, the point of view of what a reasonable legislature writing this statute have thought that these words were there to achieve. Do you align yourself with that position?
In the broad sense that what it is that the court is tasked with when statutory interpretation is being undertaken is to achieve the purposes of the legislature. The text is the primary and in most cases sole indication of what the legislature intended, as opposed to the court saying, I see this statute, but I'm, uncomfortable with how it's going to turn out or what it's going to mean, and so I'm going to import my own policy perspective. Instead, the court is constrained to say, regardless of what I think the right policy objective should be in this, with respect to this law, my purpose, my requirement is to determine what Congress intended.
But with respect to legislative intent.
All right, we're going to play around a little bit. There's Skeletor. Hold on. Why are we seeing Josh Hawley again?
Cases, child pornography cases in which you had discretion, they came before you, you had discretion to sentence one way or another in these 7 cases.
And again, back to the fact she is absolutely light in sentencing on child pornographers. And of course, Democrats just want to absolutely kiss her ass, yada yada. Hold on, what was my man talking about here?
Legitimate questions, Mr. Chairman. Don't call them attacks.
Well, I can just tell you, I have characterized them as attacks and other things as well. I think it's pretty clear what's going on here, and now you have all the information we have.
So Mr. Chairman, for example, in the questioning about the Hawkins case, Judge Jackson said she relied on the factors, relied on probation's recommendation. We just found out, and what you just...
Now, this was Republicans, given what they're worth. They were actually asking some questions about her judicial record, and Mr. Dick Durbin right here saw the right that he had to defend her, and started shutting down anything that Republicans were saying. Yeah, she absolutely, Jeff, tries to mimic that same cadence. Absolutely.
handed us that in the Hawkins case, the probation office recommended 18 months, and Judge Jackson only sentenced him to 3 months. That's you can get more than that almost for a speeding ticket. And
Senator,
this committee, given that she raised it as the basis for her sentence, it is highly relevant to the committee's analysis to see what the pre-sentence report says. Why did the probation office recommend 18 months and she only sentenced to 3 months?
March 19th, Washington Post. In the case of U.S. versus Hawkins, a sex offender had multiple images of child porn over 18. Sentencing guidelines called for sentence up to 10 years. Judge Jackson sentenced the perpetrator to only 3 months in prison.
Those facts we knew. It's the probation recommendation. We don't dispute that the guidelines said 10 years and she sentenced him to 3 months.
Sorry, I didn't finish reading it. The government and probation both recommended sentences well below the guidelines. The government recommended 24 months, probation recommended 18 months, and defense recommended 1 day. I'm telling you, it was published in a news.
I'm sorry. Let me add my thoughts to this. This guy literally had like thousands of child pornography images. Who in the hell recommends months versus years for having those images? Asking for myself, not a friend.
Newspaper. No.
Well, I can't help what is leaked to the newspaper or not. This committee, you keep referencing discovery. This is not litigation. This is a committee of the United States Senate where both sides of the aisle have a right to access to the record, and we're carrying out our constitutional duty of advice and consent.
Yeah, I do believe he tripped up on that one, Jeff, because it was, I believe, to be children under 18, and he said over 18. As far as I know, 18 is the legal consent for any state in the United States. So I believe he kind of screwed up right there.
This, for some reason, your side didn't request the information.
But how would we know to request? So I'm hereby requesting all other information you magically have that you haven't told us you have and you're not sharing with the other side.
So noted, for the record. We'll continue with the questioning now.
And
Senator
we're requesting the pre-sentence reports in particular, which are highly relevant to the issues before
Senator
this
Cotton,
committee.
please proceed. We don't have any pre-sentence reports.
Judge, I'd like to talk about crime. In 2019, there were about 16,000 murders in America. In 2020, there were more than 20,000. It's a 25% increase in 1 year. 2021 data isn't complete, but we know many cities have reached record levels of murder, including Philadelphia, Atlanta, and Milwaukee. At the same time, the prison population has decreased by about 14%, in part from pandemic policies, but also from fewer prosecutions and weaker sentencings. I think it's safe to say that there's a surge in crime, especially violent crime and murder across America. You have noted that some members of your family have law enforcement backgrounds, and I honor them and thank them for their service. Does the United States need more police or fewer police?
Thank you, Senator. As you just noted, I have law enforcement in my background, and I am very familiar with the problems that crime cause in the community.
Notice the cadence of her speech. Notice when she stops and starts. The pauses.
Communities where we live.
Okay, Judge, I'm sorry. We have a few minutes here. You have a lifetime appointment if you're confirmed. I asked a simple either or question. Does the United States need more or fewer police?
Senator, the determination about whether there should be more or fewer police is a policy decision by another branch of government. It is not something that judges have control over, and I will stay in my lane in terms of the kinds of things that are properly in the judicial branch.
Okay, if you don't want to address whether the United States needs more or fewer police, we'll move on to sentencing, which is certainly in your lane. There's been a lot of talk about criminal justice and sentencing approaches and theories today. In general, is someone more likely or less likely to commit a crime if they know that they will be caught, convicted, and sentenced?
Senator, what is in my lane is the consideration of particular cases of
Judge,
prosecution.
you've spoken a lot today about criminal sentencing, about the theory of sentencing. You've written a lot about it in your record. It is a very simple question. Is someone more likely or less likely to commit crime if they're more certain that they're going to be caught, convicted, and sentenced?
Senator, I am aware from my work on the Sentencing Commission and not as a judge that there is research into recidivism rates, into rehabilitation, into the factors that go into a determination about whether someone is more or less likely to commit crime. Part of what Congress has taken into account when it determined that one of the purposes of punishment is deterrence.
This isn't one of the most
Is the
bungling
idea that if
answers
someone
I've ever
is
heard.
convicted and punished, they will be deterred from committing other crimes.
And you've mentioned that, and you've written about that in your writings. There's 4 purposes of punishment. One of those is deterrence. Isn't it inherent in the concept of deterrence that people are less likely to commit crime if they're more likely to get caught, convicted, and sentenced?
Yeah, Jeff, they completely understand that all of this is going to come down to sound bites on the news, and not a whole lot of people are going to take the time to actually watch this shit. Or in my case, I'll be working and I'm doing a lot of other things during the day, but I'll have this in my headphones and I'm actually listening to it. They know that compared to the population of the United States, that people aren't doing that. Most of what people will get is going to be headlines, which is why they can lie to us with the absolute confidence that they do.
Why can't you just say that's the case?
Senator, it's not that I'm avoiding saying that's the case.
No, Judge, that's exactly what you're doing. I'm asking a very simple question. In general, is someone more likely or less likely to commit a crime if they know they're going to be caught, convicted, and sentenced?
It's very,
the heart of deterrence theory.
It's very difficult to answer questions in general when you're asking about things like phenomena related to crime. It's the theory behind deterrence that by punishing someone, they will be less likely to commit the crime in the future. That is a theory that undergirds.
Do you think that theory is correct?
Senator, there is research that supports that deterrence is something that can occur. Does it occur in every case? I can't say that.
Okay, let's turn to something more concrete then. Do you know how long the average inmate convicted for a murder serves in prison in America?
Now, this is a absolutely crazy statistic that he mentions here. For someone who takes someone else's life without just cause, well, let's just say they don't get sentenced to a proper term in prison.
No, I don't.
The answer is 17 years on average. Is 17 years too long or not long enough for a criminal to spend in prison for murder?
What he doesn't mention is the average is 17 years. The majority of the people who take someone's life without just cause are serving somewhere like months versus 3 years. They drive up that number with people who have committed multiple murders. Jeffrey Dahmer, the Green River Killer. They drive up that number with those people, but your average person who commits multiple murders, well, let's just say they are not serving life, and life is considered 30 years.
Senator, these are policy questions, whether they're in the province of the Sentencing Commission in terms of recommendations, whether they are in Congress. They're not the kinds of things that I can opine about.
So you don't want to opine on whether 17 years is too long or too short a sentence for murder?
Senator Cotton, the Congress has prescribed a number of factors that judges look at when they sentence. It may, in many cases, not be. I can't answer in the abstract in the way that you.
Well, these are very concrete. Let's turn to rape. Do you know how long the average inmate convicted of rape serves
I'll be
in prison
back.
in America?
Well, Senator, rape is not a crime in the federal system that I'm familiar with working with, so I don't know.
It's 7.2 months. Do you think 7.2 months is too long or too short for someone convicted of rape to be sentenced to prison?
Senator, that's a policy question about the egregious crime of rape, and Congress has said that the court is supposed to take into account a number of factors when it sentences.
Okay.
I can't answer in the abstract.
Well, Judge, these are not abstract. These are very concrete. And remember, these are just the length of sentence if you're caught, convicted, and sentenced. Let's look at cases in which people are never caught. As I said, in 2020, murders increased by the fastest rate ever in the United States. Do you know what percentage of murders are solved in America?
Majority of cases.
I do not, Senator.
The answer is about half, 54% in 2020. Do you think we should catch and imprison more murderers or fewer murderers?
Well, Senator, it's very important that people be held accountable for their crimes. So that is a fundamental tenet of the rule of law.
So is that a yes, we should catch more murderers, specifically the 46% of murderers who get away with it?
Senator, I'm not, to the extent you're asking about enforcement or law enforcement, those.
Judge, it's a very simple and common sense question. 46% of all murders go unsolved. Should we catch more of those murderers or should we catch fewer of them?
Senator, we should hold people accountable for their crimes. And so if people are not being held accountable, then that is a problem.
Let's turn to assaults. Do you know how many assaults were solved in this country in 2020?
No, Senator.
44%. So 56% of all assault victims do not receive justice. Do you think we should catch and imprison more criminals who commit assault against innocent people or fewer?
Senator, it's very important that people be held accountable for their crimes. So if they're not, then it would be a problem for the rule of law.
Let's look at sexual assault and rape. Do you know what percentage of sexual assaults and rapes go unsolved in this country?
I do not, Senator.
77%, more than 3/4 of all sexual assaults and rapes go unsolved. Do you think we should catch and imprison more rapists and sex criminals or fewer?
Senator, one of my two uncles was a detective in the sexual crimes and battery unit. So I'm very
Again, that should have been a easily yes answer. Yes, I believe we should catch more rapists. And she goes into this BS freaking talk about, well, one of my uncles.
familiar with that type of crime. It's a horrible type of crime, as are all of these that you are articulating. And it is important for people to be held accountable for criminal behavior. It's fundamental to the rule of law.
Okay. So in 2020 alone, well over 1 million violent crimes went unsolved in America. Do you think we imprison too many violent criminals or not enough?
Senator, it's important for our rule of law to ensure that people are held accountable who are breaking the law in the ways that you mentioned and otherwise.
What do you think the families of all those victims think? Do you think they think that we should arrest and convict and sentence all these criminals who get away with it?
Senator, I know what the families of law enforcement officers think because I'm one of them. I know what crime does to our society. I care deeply about public safety. And as a judge, it's been my duty when I was at the trial level, I'm no longer there, but when I was at the trial level, to ensure that people are held accountable for their crimes.
Okay. Let's turn to the crime of child pornography. I know there's been a lot of talk about it today. I don't want to spend much time on it. A lot of people have tried to explain the various differences in these cases, the pre-sentencing reports, and the sentences that they got. So let me just ask you a simple question about it. Should the United States strengthen or weaken sentences for child pornographers?
Senator, that's not a simple question, and the reason is because
That is a very simple question. Yes, if you are in possession of child pornography and you can't prove that you came to that by means that weren't, let's just say, of a nature where you enjoyed material, your ass should go to fucking prison, period. And you should stay there, period.
what this country does in terms of penalties is in Congress's province. You all decide. You all decide what the penalties are. You decide what the factors are that judges use to sentence. If you determine that any set of penalties is insufficient, then it is in your purview.
Now, she's still blowing off the fact that Congress does set the penalties for this, and they set very high penalties for this, but there's a range. There's a high range and a low range. And she was always on the low range of the penalties for this. And let's just say there are a lot of people on the left who get caught doing questionable things with younger kids, and they're quite happy to see her go on the court.
To make that determination, there are many crimes that Congress has determined warrant mandatory minimum penalties, warrant other kinds of penalties, and that is in your purview to determine.
I say, Judge, I think whether or not we should strengthen or weaken sentences for child pornographers is a pretty simple question, but I'll move on. I think the difference we've heard today gets to this simple fact that a bunch of elite lawyers, whether they're judges or federal prosecutors or public defenders or law professors, think that sentences for child pornography are too harsh. I don't, and I bet a lot of normal Americans don't either.
Well, I did a stream the other night and we looked at some of this testimony. And I brought up the fact that the left in this country is trying to actually equate child molesters with a sexual orientation and trying to normalize it. Um, and you can look that up. And guess what? Um, she is on that end of the spectrum who wants to normalize diddling children. Wonder why the left likes her so much. She is for abortion, for every gun control law, and is for diddling kids. There you go.
You have said repeatedly that sentencing is a discretionary act, and I understand that and I agree with it. But you always seem to use your discretion in these child pornography cases to reduce the sentences. I have to say, if I had that discretion, I'd probably throw the book at child pornographers. Maybe that's just me. But let's turn to drug crime. Last year, more than 100,000 Americans died from drug overdose. Drug overdose deaths and gang crime have both skyrocketed in recent years. At the same time that a lot of soft on crime laws and lower sentences have been advocated, including on occasions, Judge, by yourself. In general, do you think the United States should weaken or strengthen sentences for fentanyl traffickers? Traffickers, not users.
Senator, whether or not Congress chooses to strengthen or weaken penalties for any crime is a determination of this body, which is ordinarily made after study and review, determination. That is in the province of Congress.
Well, Judge, you've said before that sentencing is a discretionary act, so that is literally the job of the judge in many of these cases to determine whether to have a shorter or a longer sentence.
Respectfully, Senator, the judge makes that determination not based on one data point.
No, the judge has that discretion based on the guidelines given to the judge. And when it comes to cases involving children, why you are not throwing the book at these people is on you. You made that decision. Seems to me like there might be an issue with that, especially when the majority of the people that you went light on actually reoffended. I'm just saying there might be a problem there.
In general, which is what you asked me, in general, should we lower or heighten sentences? A judge is making a determination in a particular case, looking at all of the factors. It's discretionary for sure, but we do so within the bounds of a sentencing range that Congress prescribes. And at times in which Congress decides that a penalty needs to be heightened, they impose a mandatory minimum. Then our range is shorter. And when we're looking at the crime, we're not looking as a...
Oh, Jeff, she understands the questions perfectly. She just does not think that sentencing child diddlers or child porn possessors is a thing that should be done to the max, which is how most of us would deal with it, because most of us who are civilized human beings would use them for garden material and not just sentence them through 3 months.
Policy matter across all fentanyl crimes in determining whether the penalty should be increased. As a judge, we are asked in the context of a single prosecution regarding a particular person who has committed a horrible crime, but also, says Congress, is a person who has a life, who has a job, who has all of the other factors that Congress has told judges they have to look at.
Okay. Here's another one of my statements. If you harm children, if you are selling fentanyl, I don't care whether you have a life, a job, if you have children or anything else. Guess what? Your ass gets to go to jail for the rest of your natural born life. Therefore, you can no longer be a detriment to society. But that's just my humble opinion.
When they decide what penalty to impose in that particular case between the range that Congress sets. So it's not a situation in which I can, in my role as a judge, tell you as a general matter whether penalties should be increased or decreased.
I have to say, I think that not many Americans, especially not the 100,000 Americans who's lost someone to drug overdose, think these are tough questions. But let's move on. Let's talk about retroactivity. When you were on the Sentencing Commission, you repeatedly advocated for retroactively reducing drug trafficking sentences. So this is a case where a drug kingpin who's dealing fentanyl gets sentenced, and then a few years later, he gets lucky. He gets in front of some new judge who's maybe more sympathetic and thinks he got a raw deal, or maybe he just gets in front of the same judge a few years removed from seeing the faces of the victims of his crime. Do you believe that resentencing years after a conviction tends to reduce sentence lengths?
Senator, respectfully, I just wanted to remark on your previous question and your statement that these are not difficult questions. It's not that they're difficult questions, it's that they're not questions for me. I am not the Congress. I am not making policy around sentencing. My job is to look in a particular case and decide what the penalty should be within the range that Congress prescribes.
I understand. You were making policy, though, at the Sentencing Commission, and you're implementing changes to sentencing guidelines. So my question again is, do you believe that resentencing years after a conviction tends to reduce sentence lengths?
I'm not sure I understand your question. Obviously, if you resentence, you're giving the judge another opportunity to look at the circumstances in light of the changed penalties. Sometimes the judge in that new situation will keep the same penalty. A resentencing is just an opportunity for the judge to reevaluate in light of the changed circumstances.
Okay. Almost without exception, retroactively weakening sentencing laws and guidelines lets harden criminals out early. I always hear the argument, I hear it from some of the senators on this panel, I heard a version of it from you earlier, that each case is going to go before a judge and it won't be an automatic release because each judge is going to assess the facts and hear their arguments. In 2014, you said that judges would not likely reduce the sentences in the vast majority of cases if sentencing guidelines for drug trafficking were reduced. I think you missed that one, Judge. Since 2014, when retroactive reduction took effect, approximately 2/3 of all convicted drug traffickers who asked for early release got it. That's 31,614 hard.
Now, we have to draw a distinction here between two things. One are people who were violent and actually murdering people to either defend their territory or other things, and people who were merely just caught with large amounts of drugs that weren't committing any violent acts, don't have any violent history. There's a distinction in between those two said things.
Drug traffickers back on the streets. More than 7,500 of those hardened drug traffickers use weapons in their crimes. So that means that only 1/3 of these drug traffickers who sought to have retroactive reduction of their sentence were denied. Judges, 1/3, a vast majority.
Senator, it's hard for me to answer questions about these numbers because I'm trying to understand whether this is a retroactive release that was a result of the Sentencing Commission's actions or Congress's. Congress made a decision about retroactive reductions in drug penalties. So I'm just not sure what.
But Judge, in both cases, we always hear the argument, whether it's from members of Congress to include senators on this committee or the Sentencing Commission, that we shouldn't worry, there's going to be individualized case-by-case determination.
And that is my experience. That's when there is a retroactive change. So what happens is that whether it's the guidelines that are changed or the laws that are changed, which happens in Congress, there is a subsequent determination as to whether or not to apply that retroactively, apply that change, so that both the people who get convicted of that penalty moving forward and the people who have already been convicted, both of them get the benefit of the change if the determination is made to make it retroactive. Under that circumstance where you're talking about a penalty change applied to prior people, each one of those prior people goes back before a judge. And a judge, usually the sentencing judge in the first instance, will reevaluate whether or not to, this is generally, there's some exceptions, but generally speaking, the judge will reevaluate whether or not to give that person the benefit of the change. This is an individual assessment. That's what Congress requires in every sentence, and ultimately one that benefits all of us under the law, because judges are being asked to look at these cases and not make just generalized determinations.
So the 2014 comment was specifically about the Sentencing Commission, but generally, whether it's in front of the Commission or the Congress, we always hear this argument that judges are going to make these individualized cases and not that many people will be released. I'll point out that of the 1/3 that were not reduced, the vast majority of those were not eligible. The percentage of cases in which a sentence is not reduced for public safety reasons because someone is viewed as too dangerous to release that early is 1%. It's 1%. Judge, do you remember a man named Keith Young?
Yes.
Good. For the benefit of my colleagues, let me quickly cover the basics of his case. You sentenced him in 2018. Keith Young was a career criminal who had previously of trafficking cocaine. In 2017, he was running a drug business in his house where his children lived and was found with 2 1-kilogram bricks of heroin worth hundreds of thousands of dollars, along with a gun, ammunition, thousands of dollars in cash, and equipment to cut and package heroin for retail sale. The drug lab also confirmed that there was fentanyl in both bricks of heroin. And in one of the 2 bricks, there was actually more fentanyl than there was heroin. While at the D.C. jail awaiting trial, Young bragged about his arrest and about how he was a kingpin. Those are his words, not mine. Kingpin. He was even recorded calling his wife and brother to give him instructions on collecting drug money from people for him. The prosecutors filed a notice of Young's criminal history, which meant he faced a mandatory minimum of 20 years. You did not seem to like that, Judge. In fact, at his sentencing, you said, this is a quote, that you shared his frustration, that you couldn't give him a lighter sentence. I was shocked to see this in the transcript. I was also shocked that you apologized to this drug kingpin for having to follow the law. You literally said that you didn't think 20 years was fair. This is the quote, and for this, I am sorry.
Okay, this is the point where I jump back on my soapbox, and I don't agree with drug laws, and I don't agree with firearms laws. If you choose to put something in your body and you are not wrongfully depriving someone else of life, liberty, or property, I have no issue with it. None. If you rob somebody so you can get money to put something in your body, well, then I have issues with that, because you have wrongfully deprived someone else of life or liberty or property. There is, it's insane how we've got to where we are in today's society. I will. That is the best way I can put it at this point.
Mostly because I believe in second chances. You apologize to this career criminal, a drug kingpin. In his own words, he was not some low-level first-time drug offender who made a bad choice. That was in 2018. But in 2020, you got a second chance. After Young's sentence, Congress passed something called the First Step Act, which reduced sentences for serious drug traffickers with lengthy criminal records. During the pandemic, lots of criminals like Keith Young tried to twist the First Step Act's compassionate release provision, which was intended for terminally ill elderly inmates to get early release and blame it on COVID. You had none of that, and that's good. You rightly said at his resentencing hearing, quote, COVID-19 is not only present in prisons, and you said that Young's past as a smoker and his claim of various other health issues did not entitle him to early release. If you had stopped there, I would have cited that as a great example of how you follow the law and made a well-reasoned decision. Unfortunately, you didn't stop there. You said in the resentencing that, quote, Congress did not make their changes under the First Step Act retroactive, but that if they had, then you could have given him a reduced sentence. But then you said, no matter what the law says, and this is a quote, Judge, the court feels as though in this moment, per Mr. Young's compassionate release.
Well, Jeff, that is a whole nother ball of yarn, we shall say.
Motion. The court is being called upon to evaluate the length of his sentence under the revised section of the law in the First Step Act, and so it is almost as if I am sentencing him today. And if I were to do so, he would face a sentence that would be well below the 240 months that Mr. Young received. And so for that reason, I will grant Mr. Young's motion. Judge Jackson, before you granted this fentanyl kingpin's motion to reduce his sentence, did you contact any of the victims from his case?
Senator, thank you for allowing me to address Mr. Young's situation.
I asked a simple question. Did you contact the victims in his case or not?
Senator, Mr. Young was not released. His sentence was reduced, and I did not contact the victims in his case because there were no victims. He committed a crime, a drug.
Often despised, often over.
God damn it, here we go with the fat fingers again. Maybe it's drunk fingers at this point. I don't know. But she's talking about there are no victims to his crime. In some ways, I can agree with if he was not using violence to sell his drugs to protect his corner, then everybody that was involved in the transaction, you have a choice there. Whether or not your choice is influenced by addiction or not, well, it's kind of up to you. I will tell everybody this. If you go to an ER on any weekend, you will see many more people there for alcohol than you will see for any other intoxicant. And I am drinking alcohol at this point. So let that soak in. Yeah, that's about it. What did I just do? Oh, good Lord. Oh, no. We got to get the Cory Booker Crazy Eyes. Hold on. Oh, where's it at? Where does Cory Booker start out? Because we're going to end with this. Because this gets unreal painful. And I have to share love with you guys.
Seek compassionate release. To seek.
Oh, no. Just shut up. Oh.
he acknowledged was a very powerful
Here we
speech,
go,
very
Cory
moving
Booker.
speech about
You guys will
extraordinary
love
black
this.
women. I have a criticism. Your mother was not in it, but I will leave that alone. But there's some things he honed in on, almost as if they seemed to be accusations, which don't hold merit to me. We have a saying in New Jersey, I felt it was all hat and no cattle. And so here we...
All hat and no cattle in New Jersey. Do you not think he might have borrowed that statement from someplace like, I don't know, Texas, someplace that actually has hats and cattle?
He said that you called the woman who wrote the 1619 Project, that you called her provocative. That's not a compliment necessarily if you call someone provocative, is it?
No.
No, I mean, I think Ted Cruz is very provocative, and that doesn't mean I agree with.
Now, wait a second there, crazy eyes, baldy, alien head. There are many people that I might call provocative that I actually agree with. I think Ben Shapiro can be provocative. I think Steven Crowder can be provocative. I think Thomas Sowell can be provocative. And I agree with them. She was talking about the 1619 Project being provocative because she agreed with them. You crazy-eyed Spartacus moment having alien head some bitch.
What he's saying, his philosophy, doesn't mean I agree with his statements. But he pointed out you also called the author acclaimed. She won a Pulitzer Prize, correct?
She did.
In journalism. So she is acclaimed.
She is.
But in nowhere are you heralding her as this.
Yeah, you just have to be woke at this point to
so I
be
don't
an
understand
acclaimed
that
author.
at all. Part of his chart also was a lot of ellipses, skipping out things, but you mentioned critical race theory when you're talking about policies in general. I actually went back to that talk too, and I saw you threw everything in there. You were talking about psychology, economics, all different types of disciplines as touching upon the law. I think there was everything in there.
I got you,
except
Jeff.
for astrology, but you understand that you were just listing a list of things that people could say touch the law. They weren't your philosophies at all.
Correct, Senator. And that speech was not related to what I do as a judge. That was talking about sentencing policy and all of the different academic.
Okay. If I give a speech on something, and I've given speeches before in academic settings, I give that speech because that speech is something that I believe in. I'm going to scoot my computer up. She is still trying to distance herself from things that she has said that are documented. Okay. Eat the mainstream narrative if you want. Stay asleep. It's you. You do you, boo-boo.
Disciplines that might relate to it.
Yeah, and then finally, we're entering an age that is surprising to me in American society, where lots of books are being banned and lots of talks about books being read. You're on the board of a private school, and you have no supervision or authority over what books the children read in a private school, correct?
Correct.
I really do appreciate that. Jumping really quickly to a lot of talk today about these child exploitation cases. And Senator Durbin, I think that actually Josh Hawley used the word attack when describing his own. So I don't understand what that point of sensitivity was. But I individual cases, and we've now heard about two. You've presided over as a judge more than 10, 15 cases?
I've presided over 14 cases that involve child sex crimes, but over my career as a trial judge, I've presided over more than 100.
Right. And cases are heavily fact specific, right?
That is true.
Did you remember all the facts of the case that Senator Hawley was?
I did not.
You did not, right? And the facts matter, right?
They do.
And as a judge, you're looking at all of the facts of the case, not just what might be talked about later or what people are honing in. You have to take everything into account and make a decision, correct?
Yes, that's what Congress has required judges to do.
Right. And just to clarify that Congress thing, because again, you went to this elite law school. I went to a gritty inner city law school, Yale. So you know this better than me, but it was actually 1984 that the sentencing laws, the sentencing standards were passed down, correct?
I believe so, yes.
Yeah, it was 1984. And then later in 2002 or 3, things were updated. But that 1984 was before the internet completely. And I just want to clarify also the Booker decision.
Yes.
Could you just clarify for the record, because my mom might be watching, no relation to me whatsoever, correct?
So the Booker decision, which earlier I mentioned.
Jeff, that's why I watch this stuff on my own. That's the reason I will do live streams of it, is so people see it on their own. It's not edited. It's not cherry picked from any source. Basically mainstream news or anything like that. It's 100% you make up your own mind about things. And I am definitely a big fan of being presented with information and you make up your own mind. That's just the way I run things.
That I thought Justice Scalia wrote it. In fact, it was Justice Stevens.
Yes.
But Justice Scalia concurred, so he had a separate opinion, and he had written a previous decision that was very similar.
Yes.
The Booker decision made the guidelines, the sentencing guidelines, advisory.
Why? Why would the Supreme Court, joined by some of the most conservative members, why would they do that?
Well, they determined that, in essence, the Booker, that if the guidelines were mandatory, that it would violate the right to a jury trial, to have jurors decide every aspect of your sentencing.
Yeah, it's sort of the separation of powers, Sixth Amendment.
Yes.
This is really important.
Yes.
And so that gave judges latitude.
Yes.
Now, if you were falling out of the norm, and this is where, I've now read conservative periodicals looking at this line of attack. That's not a negative pejorative. Again, my colleague himself used it, but this line of attack on you, I've seen conservative papers, liberal papers, mainstream papers, all say this doesn't hold water. And the reason is, and again, unlike White House and Cruz, I don't have a chart. I'm uncharted. But I would like to hold this up for you. You are well within the norm nationally for going below the sentencing guidelines because.
So let me get this straight. So she is within the norm of sentencing people who diddle little children or watch videos of diddling of little children, and somehow that makes her decisions okay. No. If you are one of the people who actually harms children, I believe your sentence should be life without the possibility of parole. I'm still struggling with the fact that he thinks her decisions are okay when a sentencing or a prosecutor will recommend 24 months or whatever it is in federal prison, and she actually gives the guy 3 months. I'm still struggling here.
Of this problem where you have this incongruency that judges on both sides of the that have been pointed by people of both sides of the aisle have seen. I just want to make that very clear. You are well within the norm in the United States of America. I'm a former mayor. One of my.
So again, the norm for our justice system is to throw the book at people for, I don't know, having a polymer 80 in the wrong place, but they go light on people for kiddie porn. Let that sink in. Let that sink in really, really, really hard.
Favorite mayor friends used to always say, "In God we trust, but everybody else bring me data." and so the data kind of shows that you're not some outlier. And forgive me, because this is you're not allowed to do this, but I kind of sat here and was a little insulted about the accusation that somehow this mother of two, confirmed 3 times by the United States Senate, who has victim advocacy groups writing letters for you, who has child victims advocacy groups supporting you, who has presided over fact-specific cases of the most heinous crimes, that somehow the implication that you are somehow out of the norm of other federal judges that we have confirmed where these issues have never come up, who, again, I held up this chart, but the majority of the decisions, a percentage of sentences below guideline range in non-production child pornography cases. In DC, 80% of them are under the guidelines. In Missouri, 77%. And
Again, that doesn't give me the warm and fuzzies that all of these people with child pornography are sentenced under the recommended amount. That kind of shows you where our justice system is at this time.
Iowa, 62%, in North Carolina, 77%, in Nebraska, 81%, and so on and so on and so forth, down to Utah, alphabetical order, 71%. And so this implication that somehow your thoughtfulness on these very dense, fact-specific...
Now, that is another point. In alphabetical order, you can run down to 71%, and she is somewhere in the 40%. 41% of sentencing people who diddle children or have videos of people diddling children. Again, my warm and fuzzies for this chick got on the first thing fucking smoking, and I smoke a lot. Oh, son of a bitch. We got to get back to Cory Booker.
That you have to deal with. And so I said in my opening that girls, you know, you've had to deal with me juggling motherhood and job responsibilities, and I didn't always get the balance right. And so I would hope for them seeing me, hopefully you all will confirm me, seeing me moved to the Supreme Court.
Now, I understand this is a woman who has children, who can look at her own children and sentence child predators to the very lowest sentence that she can give. Me having children, I am on the opposite end of this deal. I would sentence them to the highest sentence that I could give them. But hey, I am not going to be a judge anytime in the near or not so near future.
That they can know that you don't have to be perfect in your career trajectory and you can still end up doing what you want to do, that you just have to understand that there are lots of responsibilities in the world and that you don't have to be a perfect mom, but if you do your best and you love your children, that things will turn out okay.
Well, I'm sure your mom probably feels she wasn't perfect, but things have turned out okay. And I will tell you this. I'm sure they've said it, and if they haven't, I'm sure they will. The older I get, the more I appreciate my parents. I know they're proud of you, but as a guy who does have faith, and I sit at home in a room of my ancestors where I have generations of my ancestors' pictures up, and they're black folk and white folk. I have a very interesting family tree. I sit there to feel my ancestors sometimes and think about them. I hope right now, in this questions and blistering, that you know that at that desk there are a whole lot of spirits around you with their hands on you. Not only your children and your parents proud, but so are your ancestors. Mr. Chairman, thank you.
Thank you very much.
All right, guys. I'll tell you what. That was actually day 2 of these hearings, and I'll work in day 3 at some point. And I might do another share. Well, I should do another share the pain stream tomorrow night. So, but I'm going to end this here, guys, because believe it or not, there's only so much pain that I can take and share with you good folks. So I'm going to be out. You guys take it easy, get some sleep, relax. Shit, I don't know. Take a hot shower. Don't take a cold shower. Take a hot shower. Relax the muscles. And then drift off into a peaceful sleep. Because, good God, we got enough shit coming at us right now as firearms owners that, well, it ain't going to be fun, to say the least. So, you perps be cool. I'm going to go rack out. You guys go rack out. Go rack. Get some fucking sleep. And we'll be back at this probably tomorrow night with another not so fun stream. Jeff Corn, keep the reloading coming, baby, because we got you. Yeah, Crow. It's a parade, all right. Of what? Well, insanity. That's what it is. So thank you guys for hanging around. Thank you guys for commenting and talking in the chat. Shit, I love you guys more than anything, because you guys really are the ones that, I mean, shit, you keep things going. So I don't have a freaking big talk like Dark does ending his stream or like some of the other guys. I will just say this. Be cool, perps. And yes, I will call you perps because let's face it, if you are a gun owner, you are a perp to the eyes of our federal government. And you guys be cool. Cool meaning keep that thing on you. Be polite and take care of your loved ones. I am out. Y'all take them easy.